Good afternoon, everyone. My name is Whitney Stoll. I'm your DC Post First Friday webinar host. Welcome back to our First Friday webinar series and our second webinar of the year. Thank you all for joining us here today on professional ethics for architects and engineers. Do the right thing, even when no one was watching, with our presenters from Fox Rothschild. Joined by me is Samantha Long and Bree Beal, who are behind the scenes moderating our webinar today and will also be monitoring the chat. So we have nearly 150 registered participants from all over the world ready to learn during our First Friday webinar. So please join me in welcoming our guest presenters. The Fox Rothschild legal team is going to share with you key ethical requirements for architects and engineers, providing practical guidance in real-world scenarios to navigate professional responsibilities. But first, I'd like to welcome you all, introducing you to the First Friday webinar series, which is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. The DC Post is helping sustain the future of the profession with these monthly education-focused sessions aligned with SAME strategic goals to drive partnerships, deliver solutions, and develop people. And so thank you all for joining us as we start our program. So please feel free to use the chat to introduce yourself, share your LinkedIn profile and contact information with everyone and throughout the program here today. Ask questions in the chat so we can address them during the Q&A portion at the end. Also, for those using the WebEx desktop application, you have the option to save the chat at any time by going up to File, down to Save and Save Chat. We are recording this webinar and the video on our YouTube channel later on this month. A copy of the slides, your PDH certificate, and the opt-in attendee list will be emailed to you as soon as the webinar ends. Look for document delivery in the subject line with your download following the webinar session. We're excited to provide you 1 hour of education and virtual networking, no matter where you're calling in from. We'd like to take a moment to thank our DC Post First Friday sponsors, Fox Rothschild, KCCT, Parsons Corporation, and Stantec. We truly appreciate your support and we're grateful for your generosity by making this webinar series possible. If you're not already a DC Post sponsor and would like to support our post with annual sponsorship, we'd love to add your name to this slide for future programs and events this year. Annual Platinum sponsors and First Friday sponsors help support this webinar with free registration for SAME members and full-time students. Please visit our website for more information about sponsorship levels and how you can get back to your SAME community through a DC Post sponsorship. And now it's time for the main program. Please note this program will provide one professional development hour from the DC Post. So I'm not going to read the learning objectives on the slide since most of you saw the same objectives when you registered. Instead, I'm going to introduce to you our featured speakers in just a minute. And while I do the introduction, if you haven't done so already, please use the chat, introduce yourself, share contact information, where you're calling in from, your LinkedIn profile, and who you're supporting this weekend in the Super Bowl. This is your webinar series and to help you learn about special topics, as well as help you expand your business network during the program. Please use the chat throughout the presentation to share comments and ask questions to our presenters. If there's a particular slide you want to talk about, please share that detail in your chat. We'll answer the questions at the end of the program, and don't forget to save the chat before you exit the webinar. And now please welcome our presenters. So Doug Hipschman, Keely McCarty, and Dana Molinari, the Fox Stock legal team. So welcome everyone. And now, Doug, I'll turn the program over to you.
Thank you, Whitney. Appreciate it. Good afternoon, everybody. Thanks for joining us at noon on a Friday. As Whitney said, I'm Doug Hipschman. With me are my colleagues, Keely and Dana. The three of us are government contracts and construction lawyers. We work at a firm called Fox Rothschild in Washington, D.C. We're proud members of the DC Post, and looking at the names of the folks that are attending, we recognize a lot of Post members from DC in Northern Virginia, so thanks for attending this afternoon. What we're going to talk to you about for about the next 45 minutes or so are architect and engineering rules of ethics. We understand that this was a request from one of the SME members to talk about ethics, and it's always a good idea when you're talking about ethics to have three lawyers on a call because lawyers obviously know ethics better than anybody. That's a little bit of a joke, but in general, it's not bad to have a lawyer there. And one of the things that we do for our clients is we deal with ethical issues all the time, and we deal with ethical issues and contractors dealing with the federal government, with state governments, and we also deal with ethical issues with regard to professionals such as yourselves, architects and engineers that have got to deal with licensing issues and how to act ethically under your specific set of rules. Dana, can you go to the next slide, please? So here's a brief outline of the presentation. We're going to break it up into 3 different sections. I'm going to talk first about some of the preliminary issues, and I'm going to turn it over to my colleagues Keely and Dana, and they're going to get into the specific rules of ethics. First and foremost, we'll give you a little bit of an overview about what we do as a law firm, who we are, what kind of clients we represent, what our experience is, and then we're going to talk to you about big picture, the goals of the presentation. And the goals of this presentation, frankly, are we'd like you to go out of this presentation a little bit smarter than you were coming into it on what your ethical requirements are as an architect and engineer. And for the most part, architect and engineering ethics are very, very similar. So we tried to draw some common grounds, whether you're an architect or an engineer, your requirements are substantially similar. Yes, there's some minute differences, but pretty much everything we talk about today ethically, your rules, your requirements, are going to apply to both of you as an architect and or an engineer. We're going to talk real briefly about your state licensing requirements. Everybody that's a professional architect or engineer with some state has got to be licensed or certified or registered to work in that state. That's pretty basic stuff. And then we're going to get into the meat of the presentation. We're going to talk about your specific ethical standards, how you've got to act, the things you can do and the things you cannot do to be an ethical architect and engineer. And then finally, we're going to sum up with some best practices. We'll call them best ethical practices, things that you can take away from here and use in the future to make sure that you and your colleagues and your coworkers and your company are acting ethically in pretty much every transaction and job and project that you have. Next slide, please, Dana. So just a little bit about ourselves as a law firm. Again, we work for a firm called Fox Rothschild. We are a 1,000 lawyer firm with 30 offices nationwide. We are what's called a general practice firm, which means we have a practice group for just about everything. So we do things like government contracts, construction law, intellectual property, mergers and acquisitions, labor law, you name it. If there's a legal need out there, our firm can cover it. 1,000 lawyers sounds like a big firm, but in reality, we're actually a mid-sized law firm. We're based out of Philadelphia. We're very big on the Atlantic seaboard, up and down the East Coast, and we've got offices in all the major cities across the country. We specialize, the 3 of us specialize, like I said, in government contracts and construction law. At our DC office, we have roughly 35 lawyers, and about 20 of us do government contracts and construction law. So we represent a lot of A&E firms, small, medium, and large A&E firms. We represent a lot of general contractors, subcontractors, suppliers, and we do both commercial and government contracts construction work. So we do work representing clients against the federal government, whether it be in a bid protest or a contract claim. And we also do similar things on the commercial side in handling commercial construction disputes and things like that. Next slide, please. So this is a big picture overview of the basic rules as an architect and engineer that you should be aware of. As I think you are all aware of, the primary rules that you have to follow as a licensed architect or engineer come from your state. At some point in your career, you had to be registered and or certified by your state to be a licensed practicing architect and engineer. The vast majority of those states that you get licensed through also have ethical rules. Not all of them, but the vast majority of them, say 2/3 of the states have ethical rules in addition to all the licensure rules that you have to go through. So you have to register to be a licensed practicing architect or engineer in your state. And with that comes red tape and strings that you've got to practice ethically. And there's some very, very basic ethical rules that are pretty common in pretty much every state you're going to look at. So for example, what we try to do here is to make it simple, and we drop some hyperlinks into the PowerPoint. We're focusing on Virginia. Virginia's easy, it's local. We presume a lot of the members of the DC Post and the Nova Post are licensed in the state of Virginia or the Commonwealth of Virginia. So we're using that as an example. We also have a link if you want to check out the rules for all the other states. There's a link in here that you can click to go to a clearinghouse for all of those states. But for our purposes today, we're going to use Virginia as an example. And the ethical rules that you're going to find in Virginia are substantially similar to the ethical rules you're going to find if you're licensed in Ohio, Pennsylvania, or some other state. The basics of ethical rules as a licensed practicing architect or engineer is if you do not comply with those ethical rules that your state mandates, you could theoretically lose the ability to practice in your profession. What does that mean? It means that you can be suspended or terminated from the ability to practice in your state if you do something ethically wrong. So it is important for you to understand these rules. It's important for you to apply the rules, and it's important to make sure that you are in compliance with the rules as much as possible. It's like a lawyer. Like lawyers can be disbarred from the practice of law. The same thing is true of other professionals, and architects and professional engineers are no exception to that rule. So the state rules are what we're going to focus on mostly today. There are other organizational rules out there that also have, we'll call them codes of ethics. Again, those codes of ethics are substantially similar to the state rules, but they are binding upon you if you are a member of that organization. For example, AIA, American Institute of Architects, has its own ethical rules for architects. And the NSPE, the National Society of Professional Engineers, has its own ethical code for engineers. These codes, like I said, are very similar to the state codes, but they're binding upon you only if you're a member of those organizations. So, for example, you're an architect with AIA, you're a member of that organization, and you act unethically, contrary to their ethical code, you could theoretically lose your membership with AIA. They don't bind you in a daily basis like your state rules do, but they are binding upon you if you happen to be a member of any of those societies. Next slide, please, Dana. So real basically, I've already talked about this up front, but here again, we're focusing on the Virginia rules as an example. Under Virginia code, as I've said already, and this is the code numbers if you're interested in it, and if you want to go to the code, you can click the hyperlink to do so. But basically, as an architect or engineer, land surveyor, landscape architect, interior designer in the state of Virginia, you must work under the supervision of a professional architect or engineer. All right, so that's pretty basic. If you're a Virginia architect or engineer, you've complied with this code and become certified or registered to do work in Virginia at some point. Again, professional architect, as you see by the code down below in that second bullet, is somebody that's authorized to practice in Virginia. You wouldn't be on this call, I don't think, if you were not already licensed and authorized to practice in a certain state. So this is just an example of those basic rudimentary rules that tell you that you've got to be licensed to practice in Virginia. Next slide, please, Dana. So again, as I said at the beginning, each state is going to govern how you operate and how you act ethically. All right. So basically, the states have different rules that you've got to comply with to pass and to become certified, to become licensed. And if you see the middle bullet there, states specific licensing requirements, you can click on that highlight that says here. You can go to every state and find out what the specific licensing requirements are of your particular states. Some states require you to take a test or an exam. Some states require you to submit to background checks. It does vary a bit from state to state, but again, all of you, I presume, have gone through that process already. Next slide, please, Dana. All right, so I'm going to turn it over to Keely. Her and Dana are going to talk about the specifics of the ethical requirements imposed upon you as licensed and professional architects and engineers. And I will just say this about the ethical codes that states impose. Much of this, if not all of this, is what I would consider to be very commonsensical. If you want to figure out how to be ethical as a lawyer, as an architect, as an engineer, as a doctor, or any sort of other professional out there, I will tell you, if you apply your common sense, you're going to figure out how to do it 98% of the time. There are very, very basic duties that you've got to comply with, such as the duty to look out for the safety of the public, the duty of honesty, the duty of competence, the duty to avoid conflicts of interest. All of these are concepts that you're well aware of. They're all concepts you probably learned back in middle school or elementary school. So none of it is very, very new, or it's not complex or novel. But these are rules that you may not have looked at if you've been licensed to practice for 30 years. So these rules, it never hurts to get a refresher on these rules. You can never talk about ethics too much, I don't think. And as we go through these specific rules, hopefully it will refresh your memory on you knowing these rules back when you were licensed, but also as you go forward, it's going to flesh out your duty to the public. How do you have to be competent? What's your duty of honesty? What's a conflict of interest? How do you avoid those kind of things? So I'm going to turn it over to my colleague Keely. And again, as Whitney said at the beginning, if you have any questions as we go, please drop them into the chat, and then Bree and Whitney will go through the questions at the very end, and we're happy to answer as many of those as we can. Okay, Keely,
Thanks, Doug.
turning it over to you. Thanks.
All right. Good afternoon, everyone, and thanks for being here. So I'm going to start by talking about one of the more important duties professionally, which is your duty to the public. So you all do very important work designing and engineering structures that impact people's lives every day in wonderful ways, and that also can have, you know, significant implications if things go wrong to people's health and safety and welfare. And so your primary obligation is to serve the health, safety, and welfare of the general public. And you know, your professional judgments, your decisions, and your practices all impact the public and their safety. So this one is an important one. Something that's important to know is if you do have a problem with a design or something that you're engineering and you discover it along the way, you have a duty to report any such problem that could impact the health, safety, and welfare of the general public. And it's a pretty robust reporting requirement. So to the extent in the Virginia rules, to the extent you become aware of circumstances that could impact the health, safety, and welfare of the general public, you have to inform your employer, the client, and appropriate authorities in writing of the potential consequences for those circumstances. So that's a lot of people that you have to tell, and in a particular way. They want to make sure that that people are safe and everyone knows that needs to know about the problems. It also creates an affirmative duty to the public to disclose other people's failure to comply with rules that impact the safety, health, and welfare of the general public. So not only for your own work and your own practices, but if you become aware of a colleague's mistake or something in the plans that you're reviewing that doesn't look right, you have a duty to disclose that as well. So for example, we have an example on this slide at the bottom. Your prime contractor design builder submitted a design to the Army Corps of Engineers that's structurally unsound and creates a potential danger of failure. What do you do? So hopefully you all know from our discussion of this slide that you have a duty to report those problems that you've discovered to your employer, to the client, and to the appropriate authorities in writing. The next duty is the duty of honesty, and this one's pretty self-explanatory. Basically, the regulant, which is you guys, you have to be truthful in all professional matters, and that includes in any professional reports that you submit, statements you make, you know, in the course of your job or in speaking with clients or, you know, regulatory authorities, and in testimony to the extent that you have to give testimony in any kind of a legal proceeding. You already have an obligation to be truthful in those situations, but the ethical rules in Virginia also impose this requirement. So this is a binding regulation that applies to Virginia architects and engineers, and this is a pretty common one in all states because it's such a basic requirement of the job. And it's one of the common ones where we see sanctions for non-compliance, because almost any problem that comes up ethically is probably going to involve a little bit of dishonesty in some way. So it's a pretty common one we see. So if you discover a design miss in plans and specs that you developed and you realize it's going to have a significant budget impact for your client, what do you do? Maybe this problem won't actually cause health and safety implications, but it's a mistake in another way that impacts the project. Do you have to report it? And the answer is yes, because you have a duty of honesty. If you discover a discrepancy or something that impacts the client or your work, you do have a duty to disclose it and to be honest in your dealings about that issue. All right, the next duty is relates to soliciting public work. So the biggest thing to remember in doing public projects is that you never want to offer, give, or solicit anything of value to influence a procurement, either in either direction. So, and you never want even the appearance that you may have given something or received something to influence a procurement. And that can include pretty much anything that is of value. It could be money, it could be sporting tickets, it could be travel, or a very nice dinner out. It's anything of value. So Virginia has a rule here with 3 parts that essentially says what I just summarized, that you cannot give, solicit, or receive any gratuity to influence the award of a project, or you can't give anything, solicit, receive any gratuity that could be construed as an intention to influence the awarding of a contract. And you can't provide any gift or other valuable consideration in order to secure work. So there's similar regulations to this in all the states that have ethical rules. And then there are also similar rules in the professional ethics requirements for certain professional organizations, the AIA and NSPE. So here's an example. You have tickets to the Super Bowl. I mean, that would be nice. And you want to provide the contracting officer on at a site that you work on a lot. You want to provide them these tickets, take them to the game, and talk about a future procurement that you know is coming down the pike. Can you do that? Any concerns? So yes, there are concerns is the answer. You obviously Super Bowl tickets would be considerable value. That is definitely something that is a valuable contribution or could be considered a gratuity. And if you are talking to this professional, to this contracting officer about upcoming work, even if nothing comes out of it and you don't win the contract, or it's otherwise professional, that's going to give at least the appearance of impropriety and the appearance that you're trying to influence things. So it's best to avoid anything like that. We usually advise our clients to avoid giving things of value or entertainment of high value to anyone that they're going to work on a public project with at any point in time. It's a little bit risky to go down that path because it can look improper.
And just to jump in on what Keely was talking about, all of you or most of you are federal contractors. You're all familiar with the anti-gratuity rules under the FAR. You all presumably have codes of business ethics and conduct to do work with the federal government. One part of your code is exactly what Keely's talking about, which is do not give anything of value of any sort to anybody. There is a de minimis value rule that you can give something, I believe it's under $20 to a federal employee. But our recommendation when we do our codes of business ethics and conduct, we just tell it's much easier. Don't give anything to anybody on the federal side or any sort of public side to influence any kind of work. Even if the person's your neighbor, it just is a best practice not to give anything of any value to anybody if you can help it. And I will say, if you look at federal decisions with regard to corruption and things like that, there's scores and scores of decisions out there about federal contractors giving things of value when they shouldn't, which is very, very problematic. It creates a violation of the FAR. It creates an appearance of impropriety, a potential conflict of interest. So all of them should be avoided. The same is true as if you want to look up ethical opinions in different states. In the NSPE, for example, if you want to go to their website and look at their code of ethics, they've got decisions that they've made to expel or to suspend members or to sanction some of their members for doing certain things that they're doing out in the real world as a member of NSPE. And, you know, they paid something of value. We looked up a case in Virginia where a contractor paid a public official gifts of value, whether it's Super Bowl tickets or alcohol or barbecues or even rides sometimes. It can be very, very low value, but gave it to win a, you know, essentially to curry favor in a courthouse project. And based on that, its state licensure board found that to be an ethical violation with regard to soliciting work. And then the NSPE put out a decision saying that that person was suspended from the NSPE for taking those kind of steps. And again, if you can avoid giving things of value, it's always a good idea. Go ahead, Keely.
Thank you. So moving on to soliciting private work. Interestingly, your ethical obligations also include a prohibition on offering a brokerage fee, a commission, or a payment like that in order to secure work. So you should not pay a potential or existing client in order to secure work. Similarly, this obligation includes a prohibition on any kind of misrepresentation of your qualifications. So you may not falsify or knowingly allow misrepresentation of yours or any of your coworkers or associates' academic or professional qualifications, or your experience, the quality of your prior experience on other projects. And so you're basically not allowed to puff up your resume to get work that you otherwise would not. So all the materials that you use in the solicitation of new work, new projects, have to be truthful. This is really an extension of the honesty requirement, and is, you know, understandable. So you cannot misrepresent facts concerning employers, employees, associates, joint ventures, or past accomplishments of any kind. And the AIA and the NSPE place similar ethical obligations on their members. So say, for example, your new company's marketing materials reflect that the company has over 200 trained architects, so really a big and deep bench. But you learn in the course of your work that the company actually only has 40 employees. Do you have any concerns? Do you need to do anything? And so the answer to this one is yes, there is a concern. These marketing materials misrepresent the company's qualifications, most likely in the interest of securing work. And therefore violate this Virginia ethical rule. So you have to be careful with the representations you make in securing work, not only because of the ethical rules, but also here on the slide you see there could be False Claims Act implications. So this says, you know, this slide is about private work, but often if there is any government funding involved in a project, and sometimes it's not obvious, but often there are federal dollars that are getting flowed down through states or through, you know, different avenues. If there is any federal money involved in a project, then misrepresentations of this kind or of other kinds on your pay applications can create a risk of a False Claims Act case by the government against your company or you. And those carry really hefty penalties and consequences. So under the False Claims Act, you and or your firm can be subject to treble damages. So whatever the amount of damages it is that the government suffers because of your misrepresentation, the court can triple that. And you can also be subject to penalties on every single payment application or invoice that's submitted under the project. So that can sometimes rack up into the thousands of claims, and these penalties can be between $10,000 and $27,000 each. So it adds up quickly. So the penalties are steep, and that's just one more reason to be truthful on anything that you submit to in the course of a project to your employer or otherwise.
And to compare and contrast the duty to solicit public work versus private work, the public work is very rigid. It's covered by the FAR. It's covered by the provisions that Keely just talked about. Soliciting private work is obviously much, much different. And as we talked about, giving gifts of value to the federal government or to contracting officers or project engineers, not a good idea, prohibited for the most part. Doing work on the commercial side, that's how you do work on the commercial side. You do give out Super Bowl tickets, you do give out rides, you invite people to different places. That's all fine. We're not saying that you can't do that necessarily to get business from different general contractors, subcontractors, suppliers, you name it. You can do those things. Where the line gets crossed is if you're giving something of value to get a contract of value. It's beyond just mere plain old business development. It's beyond glad handing, and it gets under state law, where state law says things are illegal, like things like bid rigging, graft, paying bribes to get work, those kind of things. So you can do a lot under a commercial contract to win commercial work, but you have to be very cognizant you can't go too far with it where it becomes a pay to play. The rules on that vary from state to state. It's kind of the Wild West out there about what you can do in one state versus what you can't do in another state. But again, like if you're a member of AIA, if you're a member of NSPE, or again, under some of your state licensure codes or your ethical codes, some of this is prohibited as well as under plain old state law. So keep in mind, you have much more flexibility in trying to win commercial work than you do on the public side, but still you do have rules and constraints and lateral limits that you do have to be aware of, that you don't cross those, because again, it can be a violation of your ethical rules.
Okay, and so that's actually the end of my piece. I'm going to turn it over to Dana for the next duty.
Great, thank you, Keely. Yes, so turning now to conflicts of interest and your disclosure requirements regarding that. So the regulant, which is architects, engineers, anybody covered by this part of the Virginia regulations, need to promptly and fully inform an employer, a client, anybody you're doing business with, of circumstances that might arise that could influence their ability to provide their services professionally and competently. This includes not accepting compensation, financial or otherwise, from more than one party for services on the same project. So you can't be playing both sides. You need to be able to fully represent your client and perform all the services required without being influenced improperly by maybe a different project or another firm that's trying to get you to work on a similar matter. If there is such a conflict, let's say you get into a project where competing interests would like you to provide services, you really do need to disclose that, make it very apparent, and ensure that both sides can agree to this. You're going to want to have them agree to any potential conflict of interest in writing, fully inform them of it, and make sure everybody consents to you doing something that could be interpreted as a conflict of interest. This is a binding regulation in Virginia. Other states have this regulation too, and there's similar rules within the AIA and the NSP Code of Ethics. And as an example, let's say your company is looking to retain a subcontractor for a federal project. You're on the selection committee, so you have the authority to pick who's going to be selected to perform this work. And your brother-in-law's company, where he's CEO, submitted a proposal. This poses several concerns. Of course, the goal here, as your role ethically, is to ensure that the right firm, the most competent firm, the best value firm is selected for the work. And you have a potential conflict of interest here. You might want to give this contract to your brother-in-law because, of course, you want to see him succeed. Now, this can be remedied, if you inform everybody of your relationship. And if this firm will provide the best value, you have to do a bit more legwork and make sure everybody's on board, but these can be worked around. However, there are some instances where it's simply just, no matter who signs off on it, is just unacceptable. There was a case from the NSPE where it concerned consulting services. In this case, it wasn't on a project. It was an engineer providing expert witness services in a case. The case concerned a man dying in an industrial accident. The estate, so the family of the deceased, brought a lawsuit against the company. And the insurance company providing the workers' comp got a local engineer to provide an expert opinion in support. The family also hired the same engineer, which sounds crazy. So this engineer was providing expert testimony on both sides of this dispute. And even though both parties knew, they signed off on it. Strangely enough, they both agreed to let this engineer provide his expert opinion. The NSPE found that that simply was a bridge too far. You were representing both sides, and even though you got consent from both parties, it was unacceptable and found to be unethical. So you just have to think, a lot of this is squishy. It can be a lot of common sense and trust your gut. If it doesn't feel right, even in this case where everybody agreed, it still was far too much of a conflict of interest. It could not be remedied. And, we do see these conflict of interest terms even in contracts. So it's governed by regulations, by professional associations, and even maybe many of you are aware, the AIA standard forms for especially cost plus projects. These terms are written into the contracts where you can't solicit subs that are affiliated with you. Let's say you're a parent corporation and one of your subsidiaries is going to submit a bid on a cost plus project. You need to make sure everybody's aware of that and is accepting of that, because again, you don't want to create this image of potential impropriety or a conflict of interest by sending business to somebody who is affiliated with your company, especially if the company has different names. So all of this is to say, these are very important and they can arise in a number of situations. So again, go with your gut. If it doesn't feel right, make sure you have people that you talk to about this potential issue and get consent, especially in writing.
And to jump on or expand on what Dana just said about conflicts of interest, the clear one, the easy one is giving work to your brother-in-law. Everybody knows that's a conflict of interest. Again, it can be mitigated at times, but again, not a good look. But the ones you're going to run into mostly is where you have a company, an architectural firm, an engineer firm that does work for both, for two entities that do not have mutual interest. For example, you're an engineering firm and you did the HVAC design for a particular project 10 years ago. Then you get hired by that owner to investigate, analyze whether that HVAC design was done properly. If you did the work initially and then you're getting hired by the owner, that's something to look at that design. That's something you would absolutely have to disclose to that owner. And again, the bigger architectural and engineering firm you're going to run conflicts checks to make sure that you avoid those kind of conflicts of interest in the future, because if you've done that design 10 years ago, you don't want to go work for the owner and critique your own work because it is a conflict. And if it is a conflict, you've got to disclose it. Maybe they will waive the conflict if you're the owner, but probably not. But those are the things that are a little bit harder to police from time to time, that you're doing double duty for parties on a different side of an equation. Go ahead, Dan.
All right, turning next to the duty of competence. This includes continuing your education just like you're doing here, but it also is a duty to not overextend yourself. The professional shall adhere to minimum standards and requirements pertaining to the practice of his own profession, as well as any professions if incidental work is performed. This essentially means you need to be skilled and competent and have experience in all of the architecture or engineering work you're providing. If your focus is in one area, you can't say switch to drafting designs for electrical if that's not you. You need to get people who are competent to do different portions of the work as necessary to provide a functional, safe, and usable final product. This, again, a binding Virginia regulation, but within the AIA and NSP, there's the same obligation to do things ethically and competently. As an example, you discover a design miss in plans and specs that you developed, which will have a significant budget impact for the client. What do? First off, you would want to make sure that this design brought together everybody who is needed to advise and create parts of this design that are applicable to the type of work they do. You don't want to overextend yourself and get into areas that you may not be certain of. And this again goes to certifying and stamping the final products. If you are not competent to do so, don't put your name on it. It can come back to haunt you. And as another example we found from the NSPE, again, it's not a Virginia case, it's an association case, but nonetheless, in this case, a county was planning to perform a significant amount of construction work for rural roads. So basic roadway construction. A local engineering firm who wanted the work and was trying to get more business put a bid in for it and assured that they knew how to do this type of work in roadway services. However, their actual specialty was water and wastewater management, so very different. They ended up getting the contract and again swore that they could do it and design it properly. Almost immediately, their designs were showing significant errors and potentials to derail the whole project. And they admitted to the county that they had an engineer that actually did not fully understand the scope of the work and what this work would entail because they were more on the stormwater front and not in roadway construction. The NSPE disciplined that head engineer and found that they breached their duty of competence in this case. So again, this is all, even though if you want to chase work, you got to make sure you know how to do it or you know somebody who does. It's very important to build a team that knows exactly how to do each portion of a project that is assigned, especially if you're more of a general contractor and you're going to have a broad range, a broad scope of work for a project. And now turning to sanctions for breach of duties. So the Virginia architect or engineer can be sanctioned by the board for a variety of reasons. The biggest one of which is failing to maintain a good moral character. So good moral character here, it's a very specific term of art essentially. And Virginia defines this good moral character as not being convicted of a non-marijuana misdemeanor in the last 10 years. You cannot be convicted of a felony that would make you unfit to engage in the occupation or profession. And you haven't committed any act involving dishonesty, fraud, misrepresentation, breach of fiduciary duty, negligence, or incompetence reasonably related to your area of practice and the services you provide. Again, a lot of this falls back on this whole dishonesty thing. Having good moral character is sometimes in law we refer to it as moral turpitude. Things involving dishonesty, misrepresentation are really treated much more sternly than, you know, any other types of trouble you might get into. And so being found guilty again of material misrepresentation, going back to that honesty factor, preventing professional incompetence, negligence, gross negligence, and violating other standards as defined by the board. This can include getting in trouble in one state where you performed work and failing to report it to Virginia. So if you're on a project in Alabama, and this has actually come up in Virginia, disciplinary actions, and you get sanctioned by that state, you have a duty to inform Virginia of that disciplinary action within 30 days, or you can get double disciplined and have Virginia also come after you. And how does this occur? A lot of times these disciplinary actions will occur when somebody makes a report to the Virginia board and they begin an investigation. And if they do find sanctionable activity, they will often reach out to the architect or engineer, other design professional, and try to draft up what's called a consent order. It's kind of like making a deal where they propose certain sanctions, which can be fines, it can be probation, it can be suspension of license, or even total revocation of license. But you work with them to draft up this order, and sometimes they're made public and sometimes they're not. And for example, in one case, one engineer took the designs of another engineer without getting their approval and stamping it as his own, and he faced sanctions of suspension of license and paying fines. And it can range a whole wide range of stuff that has come up across the Virginia disciplinary board, including False Claims Act and Foreign Corrupt Practices Act. So you engage in something where even the federal government found you liable for these things, you have to report it to Virginia and unfortunately face disciplinary action in Virginia as well. Okay, and lastly, duties to client and employers. We wanted to highlight this. This is not coming directly from Virginia regulation. This is coming from the AIA, the NSPE. So again, this is also frequently found in contract terms, but it's also an ethical duty. So you cannot materially alter the scope or objectives of a project without a client's consent. Seems pretty straightforward, but there's instances where maybe you noticed a design defect that you had and you're trying to remedy that by just changing the scope. You can't do that. You need to be forthright and get consent, often through change orders and other contractual means, to change the scope of work. You also can't disclose without consent confidential information from any current or former clients or employers. This can arise in design. A lot of IP gets involved here. So if certain design is given to the owner and they now have ownership of it, a lot of times in contracts, they'll say you can't disclose that. You must treat that as confidential. And you simply have to adhere to these obligations because, of course, you can find yourself in contractual trouble, breach of contract, but also ethical trouble within your professional association. So read your contracts, make sure you're aware of your duties because it can impact your ethical obligations as well. Okay, turning it back to Doug for some overview of best practices.
Thank you. So this is our last slide. And if you look at this slide on best practices, this could be best practices for a doctor, a lawyer, an engineer, an accountant, an architect, you name it. These best practices are pretty much universal, regardless of what kind of professional you are. So as we've gone through at the beginning and throughout the course of this presentation, best practice number one is know what rules apply to you. If you're licensed in Virginia and this is the first time you've heard about these ethical rules in 20 years, it's good that you're getting a refresher. If you're a member or a licensed professional from another state and you don't know exactly what your rules are, hit the hyperlinks in this presentation and go do a refresher to make sure you understand what those rules are and how they apply to you. Like I said, the Virginia rules we've gone over, along with the AIA rules and the NSPE rules, are going to be substantially similar to wherever you're licensed. But again, never hurts to go back and look at the source material to make sure you know how the rules apply to you. These ethical rules, again, whether it's for a lawyer, doctor, architect, accountant, engineer, they're all mostly common sense, right? So if you act ethically, if you apply your common sense in the vast majority of situations you're in, you're going to be acting ethically, all right? So just apply common sense to the projects you work on, how you bid the projects, how you staff the projects, how you work with the client on the projects. In 98% of the time, you're going to be just fine. Be honest and forthright in all dealings. Again, very, very commonsensical. The rules require it. It's good customer practice, good with working clients, to be honest. So that's kind of a no-brainer. If you think that you may be doing something unethically, or one of your teaming partners is, or one of your employees, or one of your supervisors, there's ways to find out and determine if that's actually happening. A lot of states have hotlines you can call. You can call professionals at your state and say, hey, I've got this situation. Can you help me out? And sometimes you can do that anonymously. If you don't want to call your board where you're licensed and they don't have a hotline, talk to your in-house counsel, talk to your compliance officer, talk to outside counsel if you have one, talk to your friend who's a lawyer down the street, get the answer and ask questions, because if you're not sure, look at the rules yourself and get other opinions just to make sure you've got good peace of mind. If you think something happened that's unethical, when in doubt, you probably have to proactively report that to somebody, whether it's your superiors, your clients, the government, or so on. Before you report, do your due diligence, because you never want to just report without a plan. If you go report something to the federal government that you're unethical, that's a problem, because the federal government may come down on you pretty harshly. So have a plan before you report, but when in doubt, if you don't know what to do, develop a plan to report, because you probably have to do that. And then finally, keep records. I can never say this enough to our clients. If you keep records of what you think is happening and the potential concern, and you document that, and you keep the emails, and you keep your mitigation plan, and you keep all the proactive steps that you took to keep that from happening again, it will pay dividends in the long term. So keep records as best you can. Put it in a special folder that will never be deleted. So if anybody calls you on it 8 years from now and says, you did this 8 years ago, we think that's an ethical violation, you say, no, it's not. Here's my file. Here's all the records I kept. So again, those are best practices. You can apply those universally to almost every industry or profession. But again, if you apply those in everyday life as an architect or engineer, I think you're going to do just fine. All right, Whitney, I think that's our last slide, and we will turn it back to you and Bree for any questions you might have.
Well, great. Well, Doug, Keely, and Dana, I really appreciate your time. This is definitely a critical aspect of doing business at all levels, prime or subcontractor. So definitely really appreciate this. If any of you have a question you'd like to ask the panelists, please feel free to enter it into the chat. and we can dive right into this for the Q&A. So one question we do have from Jim. I'm just going to set the table for this, and then we'll have you answer it. But Jim asks, he said, years ago, he was a PE at an engineering firm. He inherited a design build contract where we were the sub to the prime. The prime, which was the contractor, wanted to knowingly not comply with the specs regarding slope of sewer lines at a military base. I wanted to report to the government CO, but our firm's attorney told me I could not because the prime was a contractor, not us. I thought this was entirely wrong. Fortunate, I found a loophole that could get us out of the contract, and I did go report to the government CO. So Jim's asking, what would be the right answer here? What the attorney advised to protect the firm, or the alternative if I had not found a way to get out of the contract with the prime?
Yeah, I can answer that real quick, and I'll let Keely jump in too on the False Claims Act piece of it. But in general, I believe your attorney was probably incorrect on that. First and foremost, you can always report fraud, waste, and abuse to the federal government. And if you report that, regardless if it's about your prime or another subcontractor, there can never be retaliation from that reporting. So you can report all day long and anybody you think is doing something wrong, and there can be no ill effects from that, such as getting your subcontract terminated. As a federal contractor or a subcontractor, you're subject to the False Claims Act just like the prime contractor is. And if you're aware of a violation of federal law, if you're aware of a violation of the specifications, if you're aware of defective work, as a federal subcontractor, you're obligated to report that too. In general, right? I mean, if you don't report it, are you going to get in trouble for it? Most likely not. But again, every contractor in a federal contract, if they're aware of some sort of violation, whether it's specs or designs or what have you, you're obligated to report that. And Keely, keep me honest on that as far as the obligation to report as a subcontractor.
Well, yeah, it's a good question. I was sort of noodling through it. I mean, under the False Claims Act, there's no obligation under the False Claims Act, but I would think generally fraud, waste, and abuse, you're right that you always have the option of reporting fraud, waste, and abuse to the government. Under the False Claims Act, I think the risk is more whistleblowers, like that you could file a whistleblower complaint with this information, basically blowing the whistle on the contractor that's doing the incorrect thing. And as you said, retaliation under the False Claims Act is illegal. So you should not be retaliated against in terms of like your employment or anything like that, or else there's a whole separate claim for that. Yeah, it's an interesting question. I think under the ethical obligations that we talked about today, you do have that affirmative reporting duty under if it involves the health, safety, and welfare of the public, which in this case, this hypothetical, it doesn't seem to involve the health or welfare of the public. It's more of a quality of the work issue. So I don't know that the obligation to report up to the government per se would come from that ethical rule. But yeah, it does feel like there should be an obligation, which in my career as a lawyer means that there probably is. I've learned means that there probably is a requirement to report it in some way. Usually if it feels that way, it is that way legally. But I can't point to the exact rule that would require it, but you're probably right.
So short answer is you can't get in trouble for reporting it, and you're most likely required to report it, but double check. So
yeah,
that is a great question, though.
Yeah.
We got one from Bradley Flott asking, how far up the chain of command seniority are participants liable for negligence, either voluntary or by omission?
Well, companies themselves can always be liable for negligence, and key employees and or employees of those companies that were implicit in the negligence can also be held liable. It all depends on who's suing you and for what. But you can go after individual professionals for being negligent, and you can also go after companies that employ those professionals for negligence too. It all depends on the facts. But based on the question, it can go all the way up to get the entire company, to get the management, and also all the way down to get the rank and file engineer that could be complicit in that negligent act.
Okay. Uh, let's see. We got, let's see. Can Sunil asks, can an employee of a state agency privately work for another agency of the same state?
Yeah, that's one that we probably can't answer, and every state would have their own conflict of interest regulations on that kind of thing. You might be able to do it in one state and with permission of your agency, work at another agency. I don't know the answer to that. We'd have to dig into the state regs specifically. Don't know. Some state laws would probably, I know in the federal government, if you're a federal employee, you have to get permission to have another job, even if it's cutting grass somewhere. Technically, not a lot of people do it. But if you're a federal employee, I know you have to have permission for outside employment. States, I would think, would probably be the same, but I couldn't answer that without knowing the state in more details.
Got it. And what's a good website for term searchable case law for reference?
So there is a couple links that we put in for the NSPE websites, and there's ethical opinions there. There's links to AIA. And then if you wanted to check out your particular state websites for your licensing board, some states, again, not all states, publish opinions on architects and engineers that have been disciplined. So you just have to go to the specific states. I'd start with the industrial groups I mentioned, AIA and NSP first, because you can get those there.
All right. Great. We need to wrap up, but we do have a couple of additional questions. So keep entering them if you do. We just want to make sure we wrap up some SAME items before we close up. But we do have a couple of additional questions. But just stay tuned for that. Just give us one moment. But I do want to wrap up before 1 o'clock. But thank you all for participating in today's session. We really appreciate your time with us here today. It's been definitely very informative. Get a couple of great takeaways from a post. Definitely enjoyed hearing about kind of the difference between the going directly B to B versus B to G. So we had a lot of interest from our participants. So thank you all again. But before we wrap up our program today, I would like to share some of our upcoming events that we do have planned. So please mark your calendar for some of the local as well as national events that we do have planned. Our next First Friday webinar is Disaster Response Contracting, How to Be Ready to Serve, presented by Judy Bratt at Summit Insight. Judy is returning for another helpful insight webinar, this time exploring how businesses can secure government contracts to aid communities in disaster preparedness, response, and recovery. And are you interested in sharing your knowledge on current educational topics to the First Friday series with our SAME members? We are now accepting presentations abstracts for 2025. Please visit our website to learn more and submit your topic today. And sponsorships are available to help support this popular program. Several national programs are in full swing. We'd like to invite you to participate. SAME is back with the 2025 Career Transition Workshop starting next week for the career fair portion of the program, which is February 12 through 14 in Lithium Heights, Maryland. If you're interested in learning about transitioning a career in the military to private industry or a firm looking to recruit transitioning veterans, please visit us on the for the Career Transition Workshop. And don't forget the 2025 SAME Capital Week to your calendar. This is a members-only event and bring you access to leadership across the federal agencies that share their outlook on procurement, budgets, and planning for 2025. It's right in our backyard, Bethesda. And then we're getting ready for the premier training conference of the year, which is SAME JETC, which will be held May 13th through 15th in Louisville, Kentucky. And you can visit more on their website at samejetc.org. We're also being very busy here at the DC Post. DC Post is partnering with one of our local organizations, AIA DC, and hosting a sold-out luncheon later this month on designing for secure spaces, and the wait list available for those interested in attending. And wrapping up SAME Cap Week, we're going to have a lively fundraiser at Pinstripes in North Bethesda, and join us for an afternoon of bowling, lunch, and networking, all in support of the SAME Foundation. So whether you attend Cap Week or not, don't miss out on a chance to connect and unwind just steps from the conference center on Wednesday, March 26th. And are you ready for another fun event, a networking event? We partnered with the Nova Post and GovCon Rockstars again to bring you another rock climbing event. Don't miss out on this, which is going to be Thursday, June 26th at Sport Rock Alexandria, and the whole family is welcome. So we're going to be having a lot more events planned throughout the rest of the year. Be sure to visit our DC Post website for a full list of educational and social events throughout the year. Connect with us on LinkedIn, where we share industry news, event photos, and all while you build a stronger network throughout the AEC industry. You can catch all of our First Friday webinar series and sessions on our YouTube channel. And if you'd like to reach a community of 7,000 architecture, engineering, construction, and technology leaders, the DC Post annual sponsorship, you have the opportunity to leverage our networks and showcase your firm with visibility and international recognition you won't get anywhere else. Support the annual sponsorship, program sponsorship, like this First Friday series, with individual events throughout the year, like our upcoming, like some of our upcoming events at the National Press Club. Check out the benefits of sponsorship and support our mission of the DC Post with your community today. So again, thank you to Doug, Keely, and Dana. We have a couple more minutes, and with those who can't stay with us, please look for the document delivery in the subject line with slides, PDH certificate, opt-in list of registered participants today, and we will be posting this recording on our DC Post website later on this month. You also get an email from our presenter with more information of what we presented here today. And again, thank you to our sponsors, Fox Rothschild, KCCT, Parsons Corporation, and Stantec. So again, on behalf of myself, Bree Beal, and Samantha Long, have a great weekend.
Thanks, Whitney.
Yeah, so Doug, we had a couple of additional questions for you.
Sure.
So here we go. Let's see. So here's one from Kurt. Kurt asks, we have a new product, potential product we are currently pursuing for commercialization. What kind of other services do you have to examine patents, R&D partnerships, IP protection, etc. for small businesses? Sorry, it's not an ethics question.
We do IP work, and that's something that's clearly in our lane. And if Kurt would want to reach out to us, we'd be happy to talk to him about it.
Got it. And let me double check. I think I may have. Let me just double check. Voluntary. I think the only other one. I think those were all the lists. All right. I think that was it. All right.
All right.
Thanks, well, thank you, everyone. Have a great weekend.
You too.
Thank you.
Bye.
Bye.